Welcome to Chapter 5, in which we will continue our discussion of labor and employment laws, specifically as they relate to employee compensation and benefits. Once completed with this module, you should be able to describe the Equal Pay Act and apply its provisions to a modern EMS organization, analyze the Fair Labor Standards Act, and describe its basic provisions that apply to EMS, including hours of work and overtime pay requirements. Describe the Family Medical Leave Act and identify its applicability to an EMS organization. Identify the components of the Uniformed Services Employment and Reemployment Rights Act and identify best practices for EMS organizations with service members going into active service, and describe 401k plans and cafeteria plans and identify the advantages for employees who participate in such employer plans. As always, we will begin this chapter by putting the subject matter into context through a realistic scenario. In this instance, imagine for a moment that you are a female person of color recently hired by an EMS agency. When you receive your first paycheck, you discover you are being paid $2 per hour less than a white male hired on the same day as you. As we go through this chapter, consider these questions. What steps would you take to equalize your pay? How can the EMS manager assist you in this process? And what steps can be taken to avoid this in the future? While EMS providers are often very noble in their pursuits and remain in EMS out of a sincere desire to help others, it is also important for EMS providers to receive a livable wage, decent benefits, a discrimination-free workplace, and to be able to retire someday with a pension or some other type of retirement account besides Social Security. In this respect, it is important to have familiarity with the laws in place to ensure the payment of a fair wage while also protecting employees from discrimination in compensation and benefits. Additionally, as people move through their career, EMS included, there is a general expectation that pay will be increased occasionally to accommodate inflation and longevity. Opportunities for promotion will be available, and additional responsibilities may exist, thus providing greater impetus for additional compensation. This chapter will explore the management considerations related to EMS provider compensation and benefits. To begin, consider the subject of equal pay for equal work. An employee's wages are defined as the amount of money paid by an employer to an employee. Wages are commonly determined from prevailing market factors that can vary based upon the industry and geographic location. The more skilled or educated a profession requires a worker to be, the higher the compensation typically is for individuals within that profession. Professional athletes, for instance, have a very unique skill set not shared by the general public, and the amount of revenue generated by the likes of the NFL, MLB, NBA, NHL, PGA, and other professional sports organizations makes those individuals very valuable. Inversely, unskilled or simple labor typically commands lower wages as very little training or education is required, and there is an abundance of individuals qualified to do such work. Beverage servers at a professional sports venue, for instance, are typically paid minimum wage or somewhere close to that. In some instances, those services may even be provided by volunteers who are helping support a charity that receives some proceeds from vending sales. Here you have two groups of individuals within the same sports entertainment industry making significantly different wages. This type of wage disparity is acceptable, however, for the reasons just mentioned. On the other hand, if two employees are performing the same type of work, there is typically an expectation that they are being compensated somewhat equally. In environments where new employees bargain individually for wages and raises, however, a disparity may exist because one employee is more persuasive or forceful than another. Other factors may also come into play, such as education, training, experience, or a history of proven results, which is why some high-profile athletes can negotiate multi-million-dollar contracts while others are paid the league minimum. There is a unique value associated with those individual employees. In a competitive marketplace where employers are seeking to hire performing employees out of a limited candidate pool, wages and benefits are used as negotiation tools to persuade preferred job candidates to work for an entity as opposed to a competitor. This happens in the corporate world all the time, especially when companies are trying to recruit for high-profile leadership positions. Despite these various market factors, there is still an expectation that, absent these extraordinary conditions, different employees should be paid essentially the same for performing the same type of work, and a person's gender, race, religion, or other traits, unrelated to bona fide job qualifications, should not dictate the individual's earnings. Unfortunately, though, there is strong data and evidence to show that discrimination exists relative to employee compensation and benefits. Data compiled by the American Association of University Women shows that in 2014, women were generally paid approximately 79% of what men were paid. Unfortunately, when race is included in the statistics, the differences in pay are even more apparent, with some women receiving wages equivalent to 54% of that paid to Caucasian males. The premise of equal pay for equal work is that jobs of a similar nature should not pay dissimilar wages, especially if the inequity is based upon gender, race, or other protected class or status. Generally speaking, gender is the major contributor to these inequities. To combat this inequality, Congress passed the Equal Pay Act of 1963 to ensure women and men employed in similar jobs are paid similar wages. Under this law, all forms of compensation are covered, which would include overtime, bonuses, stock options, vacation pay, travel reimbursements, and other extras not typically considered part of an employee's base wage. It is important to recognize that employers may be able to justify different pay based upon factors such as seniority, merit, performance, or other elements not related to gender. From a historical perspective, the Equal Pay Act was an amendment to the Fair Labor Standards Act, which we will be discussing later. Additionally, other laws such as Title VII of the Civil Rights Act of 1964 also make it illegal to discriminate in salary and benefits based upon gender. If a woman is performing the same duties as a man with the same results and outcomes, it is difficult for employers to argue a valid reason for a difference in pay between men and women. While many would think the push for equal wages began in the 60s and the rise of the feminist movement, the first vestiges of the Equal Pay Act actually go back to World War II, when the National War Labor Board urged employers to voluntarily equalize wages between men and women. Because so many men were overseas fighting a two-front war, women started entering the workforce in droves, which provided the impetus for recognizing the value of women in the workplace, especially in non-traditional jobs such as manufacturing. Despite this encouragement, however, many employers did not correct their pay inequity and actually pushed many women out of the workforce as the men returned from fighting the war. Between 1950 and 1960, women earned, on average, 50 to 60 cents for every dollar earned by a man. In 2010, this gap was smaller, but as mentioned in a previous slide, women are still paid only about 79 cents for every dollar earned by a man. As recent as 2009, Congress passed the Lilly Ledbetter Fair Pay Restoration Act to further address the pay gap and establish a process for filing a pay discrimination complaint. To prove a violation, the employee complainant must show that men and women working at the same place doing equal jobs are receiving unequal pay. An equal job, by the way, is one that requires equal levels of skill, effort, and responsibility within a similar working environment. Assuming equal levels of licensure, EMS providers are required to function with the same level of skill, effort, and responsibility in a similar working environment, regardless of whether they are male or female. As a result, EMS managers must ensure employees of different genders are paid equally. As previously mentioned, the Equal Pay Act was a provision added to the Fair Labor Standards Act, which is a law that defines numerous workplace benefits related to hours and wages that are often taken for granted today. When passed in 1938, the FLSA established the 40-hour work week, the right to overtime pay, and regulated the work of children under the age of 16. It also created the Wage and Hour Division of the Department of Labor to set standards for minimum wage, overtime pay, record keeping, and youth labor. Some important provisions of the FLSA establish the payment of a minimum wage as established by Congress for non-FLSA exempt workers. Overtime at 1.5 times base hourly pay is also required for any non-exempt employee working over 40 hours per week. There are some exclusions within the FLSA, such as the firefighter's exemption, which increases the number of hours a firefighter can work in a week before overtime is paid. This provision exists because many firefighters work a 24-hour shift, which typically results in a weekly working average well in excess of 40 hours. This 7K exemption, as it is called, is permitted only for government employees, however. Private employers cannot utilize this exemption. Also, for those in government employment, the 7K exemption only applies to those employees who participate in fire protection activities. Thus, if a fire department or other public entity employs EMS providers who do not provide fire protection activities, those individuals must receive overtime pay once they exceed 40 hours in a week. With the recognition that fatigue can be an issue within the fire and EMS professions, some states may have laws that prohibit employees from working multiple 24-hour shifts without a mandatory break in between. Such laws are permissible under the FLSA. As an EMS manager, it is also important to understand the difference between an FLSA exempt and non-FLSA exempt employee. Non-exempt employees are entitled to overtime pay in excess of 40 hours, where exempt employees, such as those at the supervisory or managerial level, are not. To determine whether a person is exempt from the provisions of the FLSA, it is necessary to look at the job duties performed by the individual. How much and how the employee is paid can also be factors in the analysis. Simply calling someone a salarized employee does not mean the employee is automatically exempt from the FLSA and the need to be paid overtime, as there is also a guaranteed minimum wage threshold that must be met to be considered a salarized employee under the FLSA. The primary job duty a person must perform to be considered FLSA exempt is the supervision of multiple employees, which includes hiring, firing, promoting, or assigning individuals. Thus, an ambulance crew chief is probably not exempt from the FLSA overtime provisions simply because she is responsible for 2 other people on her crew, unless she has the ability to fire those individuals, which is probably not likely. Even if a person performs other duties, once an individual qualifies as an exempt executive under the FLSA, that individual remains exempt even if performing other duties, such as an EMS chief who also responds on calls. Again, having input into personnel matters is typically key for identifying individuals who qualify as exempt executives under the FLSA. Beyond the exempt executive who manages and supervises people, the FLSA also recognizes an exempt professional job category for individuals who perform work that is intellectual in nature, requires specialized education, and involves the exercise of discretion and judgment. Such employees must typically have education beyond high school or even beyond undergraduate college work in fields that are distinguished from the mechanical arts or skilled trades. These professionals include engineers, doctors, lawyers, architects, and others in similar positions. To clarify, firefighters and EMS providers do not qualify as exempt professionals under the FLSA. There are also exempt administrative professionals who perform office or non-manual work directly related to the management of general business operations of the employer or the employer's customers, where a primary component involves the exercise of independent judgment and discretion about matters of significance. Ultimately, these are high-level employees whose main job is to keep the business running. The determination as to whether or not an employee is considered exempt by the FLSA is an important one, in that exempt employees have virtually no rights under the FLSA overtime rules. This is why the fire chief or EMS service director may work in excess of 40 hours per week without receiving any additional compensation or overtime. For the most part, the only thing the FLSA does for an exempt employee is ensure he or she is paid the full amount of the base salary in any work period during which the exempt employee performed any work, minus any permissible deductions. While the FLSA does mandate overtime pay after 40 hours of work per week, it does not restrict the number of hours an employee can work, including mandatory overtime hours imposed by an employer. In the emergency services field, this is important as an agency has the right to order a person to work even if it would result in overtime, so long as the employer is willing to pay the overtime. In addition to the wage and overtime provisions within the law, the FLSA also covers equal pay for men and women, child labor, unpaid breast pumping or nursing breaks, coffee or rest breaks of 20 minutes or less, premium, holiday, and weekend pay, and shift differentials. The FLSA does not mandate the employer to provide raises, nor does it cover pensions or retirement plans. Your textbook provides additional information on the Fair Labor Standards Act, and there are also numerous online resources available for those interested in the subject. The U.S. Department of Labor Wage and Hour Division has numerous resources available on its website regarding the FLSA, including posters, handbooks, fact sheets, and opinion letters. As an EMS manager responsible for ensuring compliance with the FLSA, it is important to have more than a passing familiarity with the law. These resources, in addition to working with a labor law attorney or human resource specialist, are essential for anyone who manages employees. Also keep in mind that at the time this presentation was prepared, there is a proposal from the Department of Labor to update FLSA rules that would potentially double the standard salary threshold level for overtime-exempt employees and broaden federal overtime pay regulations to cover additional employees. Given regular changes to the law, it is important for you as an EMS leader or manager to stay well informed and seek advice from an attorney or HR professional when employment issues arise. While not quite the same thing as the Fair Labor Standards Act, Wisconsin does have a state statute that defines employment regulations. Chapter 103 of the Wisconsin statutes covers many employment requirements such as the hours of labor, family or medical leave, records open to an employee, age minimums, and numerous other provisions that provide additional protection beyond those within the FLSA. Another piece of federal legislation that has significant impact on employers is the Family Medical Leave Act. This law allows eligible employees with covered employers to take unpaid, job-protected leave for specific family and medical reasons without losing health insurance benefits or having to worry about losing their jobs. Eligible employees are entitled to 12 work weeks of leave in a 12-month period. The circumstances under which an eligible employee can take family medical leave include the birth of a child, care for a newborn, the placement with the employee of a child for adoption or foster care, to care for the employee's spouse, child, or parent suffering from a serious health condition, the employee's own serious health condition, or any qualifying exigency arising out of the fact that the employee's spouse, son, daughter, or parent is a covered military member on covered active duty. Eligible employees are also entitled to 26 work weeks of leave during a single 12-month period to care for a covered service member with a serious illness or injury. In order to qualify for FMLA benefits, the employee must work with a covered employer for a total of 12 months and must have worked at least 1,250 hours over the previous 12 months. To be a covered employer, the workplace must employ at least 50 employees within an area of 75 miles. Public agencies are covered regardless of the number of employees. Under some circumstances, employees may take intermittent FMLA leave, which allows them to take leave in separate blocks of time for a single qualifying reason. Additionally, for employees who have paid leave benefits, the employee or employer may choose to substitute or concurrently utilize accrued sick paid leave to cover some or all of the FMLA leave. Some employers may actually mandate the use of accrued paid leave while on FMLA leave. If your agency is a covered employer, it is required to maintain health insurance coverage for an employee on FMLA leave whenever such insurance was provided before the leave was utilized. Once the employee returns from FMLA leave, that employee must be returned to his or her original job or an equivalent job. Additionally, an employee's use of FMLA leave cannot result in the loss of any employment benefit that the employee earned or was entitled to before using FMLA leave, nor may it be counted against the employee under a no-fault attendance policy. While the FMLA was written predominantly to protect workers, the law recognizes that employers must have the autonomy to run their business. As a result, employees seeking to use FMLA leave must provide 30-day advance notice to the employer, or, if that is not feasible, such notice must be provided as soon as practicable. Employers also have the right to obtain sufficient information from the employee to reasonably determine whether the request qualifies for FMLA leave. Similar to the FLSA, the FMLA requires employers to post notice of employees' FMLA rights and responsibilities within the workplace. Employers must also include the general notice in employee handbooks, distribute the handbook to new employees upon hiring, notify the employee of eligibility to take leave, inform the employee of rights and responsibilities under the FMLA, and also notify the employee if leave is ultimately designated as FMLA leave. It is unlawful for any employer to interfere with, restrain, or deny the exercise of any right provided by the FMLA. It is important to recognize that many states also have their own family medical leave laws that may provide additional benefits to employees over and above those provided by the federal FMLA. Within Wisconsin, family or medical leave is governed by Statute 103.10 and Administrative Rule DWD 225, which provides details as to the logistics of the leave and the process for filing complaints against an employer. If an employee qualifies for leave under both the federal and state FMLA, the provisions that are most favorable to the employee are applied. Additionally, the leave provisions run concurrently, meaning the employee cannot take a full allotment of leave under the federal FMLA and then attempt to take additional leave under the state law, assuming the federal FMLA provides more time than the state law. If an employee qualifies for leave under only one of the two, federal or state, the leave counts against the allowance within that specific law. There is nothing that prohibits an employer from offering leave that is more generous than that provided by either the federal or state FMLA provisions. While not specifically discussed within the textbook, a relatively new law, at least at the time this presentation was produced, impacting employee benefits is the Patient Protection and Affordable Care Act. Often referred to simply as the Affordable Care Act, or ACA, the threshold for when an employee is considered full-time eligible for benefits occurs at 30 hours, which is different from the 40 hours used by the FLSA to define when an employee is entitled to overtime. The ACA is a very complex piece of legislation that has far-reaching implications for employers, assuming the employer is covered by the ACA, which hinges predominantly on the number of people employed by the business or entity. Places of employment with less than 50 employees are below the threshold for the ACA. An exploration of the ACA is beyond the scope of this class. It is important, however, to be aware of its existence and understand the need to seek help in determining how it applies or does not apply to your organization, as penalties for violating the ACA can be significant. One interesting caveat, however, is that significant political pressure resulted in volunteer fire departments not having to worry about supplying paid health insurance benefits to its volunteer staff. Protective services disciplines tend to see a lot of military reservists within their pool of employees. To protect the jobs of servicemen and women while they are away on deployment, Congress passed the Uniformed Services Employment and Reemployment Rights Act of 1994, which guarantees uniformed service members a variety of reemployment rights. Under USERRA, an employer must reemploy service members returning from deployments to the position in which they would have been employed had there been no interruption by military service. Employers are also required to provide non-seniority benefits, such as accrual of vacation leave, to employees who are away on military leaves. The goal of USERRA is to ensure members of the Armed Forces, Reserves, National Guard, or other uniformed services are not disadvantaged in their civilian careers because of their service to their country. Part of this is to ensure such service members are promptly reemployed in their civilian jobs upon return from duty, and that they are not discriminated against in employment due to past, present, or future military service. Under the provisions of USERRA, an employee must provide advanced written or verbal notice of the military service. The absence cannot exceed 5 years. The employee must not have been dishonorably discharged or released under punitive conditions, and reemployment is sought within a specific time frame, given the length of military service requiring the leave, to be eligible for mandatory rehire with the employer. In some cases, it is not merely enough that the service member return to a previous job if it is likely that the employee would have been in a different position if continuously employed during his or her military service. Complaints related to USERRA violations are filed with the U.S. Department of Labor Veterans Employment and Training Service. Failure to comply with USERRA could result in paying lost wages and benefits. If it would have been likely that the employee would have progressed within the organization or received raises, those factors would also be considered when determining the financial award to the returning veteran. Double damages, attorney's fees, and litigation expenses can also be levied if the violation is considered willful. If your EMS agency has any service members subject to USERRA protections, it is of utmost importance that you are familiar with the law's requirements to avoid the risk of significant liability. When considering compensation and benefits for your EMS providers and other employees, it is important to help them plan for the future and eventual retirement. This is where IRS qualified retirement plans come into play, specifically 401k plans in which employees can make salary deferred contributions on a post-tax or pre-tax basis. Employers may also make matching or non-elective contributions on behalf of eligible employees. Many such plans are set up on a deferred compensation model where contributions are not subject to income tax withholding at the time of deferral, meaning the employee pays the income tax on the money as it is paid to him or her in retirement. Given the time value of money and compounding returns, EMS employees are wise to invest in a retirement plan as early as possible in their careers. If an employer provides any type of matching or percentage contribution, it is also in the employee's best interest to maximize those contributions. While there are many factors that impact employee retention, wages and benefits are one of them, and having a strong retirement system in place for employees provides a persuasive incentive for them to remain with the organization. As mentioned previously, employees are encouraged to contribute at least enough to qualify for an employer's maximum matching contribution. This is essentially free money for the employee. The employee typically does not pay any tax on employer contributions until they are withdrawn during retirement. Many 401k plans allow employees to make a hardship withdrawal because of immediate and heavy financial needs. To discourage such behavior, however, the IRS penalizes such distributions with an additional 10% tax if they are taken prior to reaching retirement age. There is also the option to borrow against the equity in the account, although this is something the employee should avoid if at all possible. After all, the retirement funds are supposed to be for retirement. Not contributing or using a retirement account as additional or routine funds is short-sighted and harmful to an individual's retirement plan. There are some things an employee can do with money in a 401k plan before retirement without having to pay additional taxes on the money. First, if the employee takes the money out and rolls it over into an individualized retirement account, IRA, within a specific period of time, it is not considered a distribution from the 401k plan. There is no tax to be paid at that time. On the other hand, if the person converts the funds into a Roth IRA, then the employee must pay the tax on the money without the 10% penalty. The benefit of a Roth IRA, however, is that the money then grows tax-free. Paying tax when the money is earned is typically very beneficial as that money will grow over time and the gains realized in the Roth IRA account are tax-free. If the employee leaves the organization and is hired by another entity with its own 401k plan, there is a benefit to consolidate financial resources within a single plan, so moving money from a former employer's plan to a new employer's plan can be done without paying tax on the money at the time the transfer occurs. Regardless of where the employee goes afterward, if he or she leaves employment and is not at retirement age, the employee can always just let the money sit in the retirement account. Given a separation in employment, it is possible to cash out and take the money as a distribution. If the distribution occurs prior to being 59.5 years of age, however, the distribution will not only be taxed, but it will be subject to the 10% penalty previously mentioned. If your EMS agency is a governmental or specific type of nonprofit entity, you may have a defined contribution 457 retirement plan, otherwise known as a pension. Within these plans, the money grows tax-deferred until it is withdrawn in retirement, at which time the retiree pays the income tax on the funds received from the plan. Within Wisconsin, State Statute 40 defines the Public Employee Trust Fund, which is the Wisconsin pension system for governmental employees. Further regulation is provided through Department of Employment Trust Funds Administrative Rules, which cover topics such as administration, appeals, healthcare benefits, disability benefits, survivor benefits, and other related subjects. While not a retirement plan, it is also important to know about cafeteria plans whereby an employee may have an opportunity to receive certain benefits on a pre-tax basis. Under such a plan, a qualified benefit does not defer compensation, yet it is excludable from the employee's gross income. Examples include accident and health benefits, adoption assistance, dependent care assistance, group term life insurance coverage, and health savings accounts, including distributions to pay long-term care services. Employees must also choose at least one taxable benefit, commonly cash. With all of that information, it is now time to revisit our initial scenario in this presentation. How would you handle a situation in which you are being paid less than a similarly situated employee, arguably based upon your gender and/or race? The first step would be to note the wage disparity and bring it to the attention of your manager in an attempt to have your wage elevated to be on par with the Caucasian male employee. Back pay should also be received. If the employer does not respond, the next step would be to file a formal complaint with the employer and copy the respective state wage and hour division of the Department of Labor. Many are afraid to file such complaints for fear of retribution from the employer, typically in terms of being fired. Such retaliation is illegal, however, and it is important for you as an employee to seek enforcement of your rights under the FLSA, the Equal Pay Act, and Title VII of the Civil Rights Act. To avoid such a situation, it would be beneficial for any employee starting work with a specific agency to be familiar with the salary or wage to be paid for scheduled work hours. Having an understanding of overtime available if you work in excess of 40 hours per week is also important. Returning back to the role of an EMS manager and leader, it is important to understand the basic components of an employee's rights and some of the financial and health benefits afforded to employees. Within these topics is the concept of equal pay for equal work, given the applicability of the Equal Pay Act and the Fair Labor Standards Act. Employers must be very familiar with equal pay and overtime requirements, along with the rights afforded to returning veterans under the Uniformed Services Employment and Reemployment Rights Act. EMS managers must also keep in mind that an organization's structure can impact the applicability of some of these laws. Ultimately, many of the laws applying to the employment relationship between an employer and employee are very complex. Given the cost associated with failing to follow the laws as it relates to labor and employment law, it is highly likely that an EMS manager will need to consult an attorney or human resources professional for guidance on how to handle all but the most routine issues that may arise.